Welcome everyone. We'll get started in just a minute. Kathleen, I'm ready whenever you are.
Wonderful. Well, welcome everyone. Thank you so much for joining us for today's Lunch and Learn, Making Polluters Pay, Inside the Court Battles for Climate Accountability. Since 2017, 5 states, 20 municipalities, the District of Columbia, they've all turned to the courts to hold fossil fuel companies accountable for their role in the climate crisis. Alyssa Johl, who is the legal director of the Center for Climate Integrity, and Anthony Moffa, an environmental attorney and associate professor of law at the University of Maine School of Law, are with us today to share the status of climate accountability lawsuits, explain the arguments they make, and the case for climate accountability in Maine. Thank you so much for joining us, Alyssa and Anthony. My name is Kathleen Neal. I am the Director of Policy and Partnerships at Maine Conservation Voters, Maine Conservation Alliance. Our organizations represent more than 8,500 members and supporters dedicated to protecting Maine's environment and our democracy. MCA does that through education, collaboration, and advocacy, and MCV by influencing public policy, holding politicians accountable, and winning elections. A few logistical notes for today. We will hear from our speakers and then tackle questions in the Q&A session at the end. You don't have to wait though. You can send your questions to me through the chat whenever they occur to you. I'll keep track of them and ask them in the Q&A at the end. You can message Will Sedlak at any point if you have any technical difficulties. This event is being recorded and the video will be posted on our website later this afternoon, where you can also find recordings of all of our previous Lunch and Learn programs. Thank you again for joining us. And Anthony and Alyssa, I will turn it over to you.
Awesome, thank you. Thanks for having us, and we're excited to talk with you today about this topic. Let me share my screen here. Okay, so we have some slides. We tried to keep it a little bit light on that front though. So I'm going to talk first about set the context a bit about climate change in Maine and the impacts, and also what the underlying theory might be for some of this litigation that Kathleen mentioned that's been going on. And then Alyssa is going to provide us with some more detail about some of that litigation and a bit more information about some specifics. So I want to just start by putting this in context of the impacts that we're already seeing here in our very own state as a result of climate change, in particular, warming seas and rising seas, and the greater incidence of storms that are of severe intensity. And these are just some photos. You can see some flooding in Portland there and flooding in Farmington as a result of some of those severe storms. And then there's a nice picture of a lobster. We couldn't have a presentation in Maine without one of those. And that's there just to remind you that, or to reiterate the point that one of the, perhaps our most iconic industry has been in the past, decade, been experiencing a boom. And that boom is in some ways attributable to the warming waters of the Gulf of Maine. And that's great for lobstermen right now. But what perhaps we're not necessarily considering is that as the waters continue to warm, projections indicate that we're going to see a decrease in that lobster population and lobster landings as a result. So our lobster industry is likely going to suffer if the current trajectory of warming in the Gulf continues. And so those are some pretty costly impacts. And just to continue that conversation, you can see this map here on severe storms. And you can see at the number of severe precipitation events has been steadily increasing over time. And indeed, you can see a large spike in the late 2000s. And that's pretty directly attributable to climate change. The cost of these impacts is quite significant, right? The buildings that we're going to have to do to make our communities more resilient to the impacts of climate change is going to cost us billions of dollars here in the state of Maine. And so the question that this all begs is who's going to pay the cost of this very significant changes that we're going to have to make to our state. Just one last figure that I think drives this home for a particular industry here in Maine that's not lobstering. These are projected snowfall declines and the bands across the state. So if you think about our winter tourism industry as something that you care about, again, that's another industry that's going to be severely impacted. So how could we find money to pay for the resiliency impacts, or the resiliency programs that need to be instituted in the communities displayed on this map, for instance? Well, one place to turn, right, is the government and the legislature of Maine, and indeed the federal legislature, and there are efforts being made right now in Washington to try to get some infrastructure funding to do some of this work. But in my mind, the first thing that comes to mind for me as a lawyer, as a scholar of tort law, is who's responsible for this cost, right? Who is imposing this cost in our state? We didn't choose for climate change to happen to us. And so maybe we as taxpayers shouldn't bear the full cost of this. And so that's where the courts come into the equation, because courts have historically played this role in our society of providing compensation for environmental harm. In fact, if we talk about environmental law as a subject of legal study, right, nuisance and trespass, which are two very, very old tort causes of action, right? You're probably all quite familiar with the idea of a trespass, are the original environmental laws, right? They're about something interfering with or invading land, right? Messing up your property, right? Or your use of that property. That's environmental law 101, right? And so what we're talking about here is kind of the 21st century reimagining of those early environmental law concepts, right? This isn't about solving climate change, but it's rather about who's responsible to pay for the cost of climate change that we know is going to happen, right? And it's already happening. And if you're familiar with the terms mitigation and adaptation, a lot of what we're talking about today is who's going to pay for adaptation, right? And so or at least what we're discussing is how do the courts get involved in paying for that adaptation? And as I mentioned, right, you have these two old common law causes of action, nuisance and trespass. And so how do they relate to climate change? Well, nuisance is about when someone interferes with, their activity interferes with your use and enjoyment of property. And when we're talking about a public nuisance, it's the use and enjoyment of property that we all hold in common as members of the public of the state of Maine. There's a lot of property that's held that we can think about in this way that's been interfered with by climate change. We mentioned a lot of it at the beginning, right? The fishing industries here in our state, right? The flooding that's happening on our towns and our streets, right? Coastal property, it's not owned by anyone, that's being eroded rapidly because of rising seas. This property is all being interfered with as a result of climate change, as a result of the activities of some of the largest fossil fuel corporations in the world, who have for a long time, as Alyssa will talk about, known about this issue and really done nothing to abate it. So that's one theory of the case. The other theory of the case focuses on that knowledge that these industry players had, and their hiding of that knowledge from the consumers who purchase their products, right? There is a whole body of law around fraud and consumer protection that demands that these corporations that act in this way, that don't deceive us as consumers when we purchase their products. There's a lot of information out there, evidence that these corporations did just that when it comes to climate change, that they knew about climate change happening. And in order to keep selling fossil fuels to us and make us feel like they were having minimal to no impact on the environment, they just didn't tell us what they knew. They didn't disclose what they knew in SEC filings. They didn't advertise what they knew. In fact, they worked in opposition to getting that science out there from major public universities and other researchers who were working on early climate science. And so that's a problem, right? It's a problem for society. It's also a problem in the eyes of the law. Right? You have consumer protection law and fraud laws to challenge just that type of illicit activity. And so I want to turn it now to Alyssa to talk a little bit more about that growing body of evidence on those topics and get a little bit more into the details of these particular cases.
Thanks, Anthony. That was a great setup because, you know, I think deception is really at the core of the two theories that you described, both the nuisance and trespass types of damages cases that are being brought and the fraud and deception cases. But the deception is really at its core. And the reason why we can tell this story is that hundreds of internal industry documents have come to light over the past 5-10 years that really paint the picture of what the industry knew, when they knew it, and what they did with that information. Do you want to go to the next slide? So in terms of the early knowledge that the fossil fuel industry had, as early as the 1950s and no later than 1968, fossil fuel companies had knowledge of the risks associated with their products. And this is just a snapshot of one article of many. In fact, there have been books written about this that really detail what the industry knew and when. The reality was that during the late 1970s and early 80s, Exxon and other fossil fuel companies were really at the cutting edge of climate science. They were at the forefront, running the most innovative research programs, oftentimes in partnership with research institutions, government, and others. And their scientists were well aware of the fact that CO2 concentrations in the atmosphere were increasing, that increase was attributed and directly caused by their products, and that a warming world would have devastating harms. If you can go to the next slide, you know, what they actually predicted was that there would be catastrophic harm. And this is one document, a memo written by an Exxon scientist, Roger Cohen, back in 1981, that describes the catastrophic effect that it would have on the Earth's population. We have several other documents where that same language is used by other companies as well. And these scientists were making eerily accurate predictions back in the late 1970s and early 80s that really have come to bear in terms of what we might expect of climate change and the greenhouse gas emissions that their products, you know, emit. So around the mid 1980s, I would say the tables turned entirely. You know, rather than disclose or take the steps necessary to protect the public, the fossil fuel industry concealed that information, as Anthony mentioned, about what they knew. And they ran these incredibly misleading marketing campaigns to create doubt and uncertainty. They funded scientists and front groups to advance their agenda. And all of this was in direct contradiction to what their own scientists knew and the actions that they were taking to shore up their own assets and operations. They were raising offshore oil platforms to account for sea level rise and taking other measures to make sure that they were adapting to a changing world, all the while lying to the public and concealing that information. This is a victory memo, or one page out of what we refer to as the victory memo, that was produced by the American Petroleum Institute. It was part of a broad communication strategy that they undertook in the late 1980s in the aftermath of the adoption of the Kyoto Protocol. And there, you know, this was very much an intent to influence Congress, block ratification of the Kyoto Protocol. And as you can see, I mean, their victory will be achieved when average citizens understand uncertainties in I can't even read the language, in recognizing climate science. So I think, all this to say is that they were incredibly successful in their communication strategy. As you may know, the Kyoto Protocol was not ratified by the US. And, they have, through their communications and their marketing campaigns, effectively changed the trajectory of climate policy and in the US and international. And this deception continues to this day. If we can go to the next slide. Modern day deception looks different than what it did in the 80s and 90s and early 2000s. I'd say that, modern day deception takes the form of greenwashing. Exxon and others market and sell their products as clean, greenhouse gas reducing, and beneficial to the environment when they're not. They falsely promote themselves as environmentally responsible, clean energy leaders, and they promote themselves as, responsible corporate citizens, yet all the while doubling down on the production of fossil fuels and really investing very little in the production of alternative fuels and renewables. This photo came from an investigation that came to light just about 2 weeks ago, and I'd recommend Googling it and searching. This man's name is Keith McCoy, and it was an investigation done by Greenpeace that exposes two former Exxon, well, now former, one was fired as a result of this investigation, but it exposes what they knew and how, the tactics that they use. This person in particular admitted to the fact that while they publicly support climate change legislation and claimed to support climate change solutions, they're very much lobbying against climate legislation behind closed doors. So it was a pretty damning made in their own words by their own industry lobbyists. So with that, and that's really just a whirlwind history of the deception and denial by the industry. We have lots more information to show, and I'd recommend taking a look at Climate Files, which is a one-stop shop for all of the documents that you might be interested in on this issue. But I wanted to go ahead and just kind of take a look at, well, how are communities across the country responding and addressing this? And I know Kathleen mentioned at the onset that there is a wave of lawsuits that have now been brought by 26 communities across the country. There are 20 cities and counties, 5 states, and as well as the District of Columbia, and 1 industry trade association. And I wanted to spend a moment on this. I think it would be of particular interest to those of you in Maine. It's the Pacific Coast Federation of Fishermen's Association out in Oregon and California has filed suit for climate damages that have resulted in closures to crab fisheries. So I think that's certainly relevant to some of the conversations that are happening here in Maine with respect to the effects on the lobster fisheries. And something to a discussion that might be worth having. But just to give like a general overview of, sort of the litigation and the state of play, the first cases of these, 26 communities, 1 trade association were filed back in 2017 under the theories that Anthony mentioned. Many of them have been held up by procedural delays brought by the industry. They have brought challenges pretty much at every step of the way. What has generally happened is that these cases are filed in state court, then the industry defendants remove them to federal court where they feel that they have a better likelihood of success of having these cases dismissed. And then once they're in federal court, the federal courts send them back to state court, saying that there isn't this doesn't necessarily arise under federal law or implicate a federal interest that would prevent it from being heard in state court. So at this stage of the game, 4 years after these first lawsuits have been filed, a number of these procedural hurdles and obstacles have been overcome. There have been appeals to the US Supreme Court. Most recently, just last month, the Supreme Court refused to accept the industry's most recent appeal, asking the court to determine whether the cases should proceed in state or federal court. So leaving it to the lower courts to determine that for themselves. So these recent decisions by the Supreme Court, by other courts around the country, really send a strong signal and give a green light for many of these cases to proceed in state court. And that's what we are going to start seeing over the coming months and years. I just wanted to highlight a few of these cases because I think geographically, regionally, they might be of interest. There have been suits brought by the Massachusetts AG, AG Healy, Rhode Island, and Connecticut AGs as well. And I just wanted to briefly mention, because some of these are sort of at the forefront of this wave of litigation and really are going to shape what comes next. The lawsuit in Massachusetts was filed against Exxon for misleading both consumers and investors about the harms associated with their products and the risks that climate change poses to its business model. This was the first court, the Massachusetts State Court was the first one to issue a decision on a motion to dismiss. And this is pretty exceptional because we've been waiting for this moment. Essentially, for the non-lawyers in the group, what happens after motion to dismiss is that we now can proceed to litigating the merits. The case will proceed to discovery and then ultimately trial, and we will have resolution on this case in the coming years. That's not to say that the industry won't set up additional obstacles and roadblocks, but it's on a path forward, and AG Healy is well positioned to take that forward. The suit in Rhode Island, which was the first suit brought by a state AG, was filed against 21 companies seeking to recover the costs to address past and present climate damages. And the parties had been in the process of litigating a motion to dismiss, but that case has been stayed pending the outcome of a personal jurisdiction case in the Rhode Island Supreme Court. So as soon as that Supreme Court case is resolved, this case will move forward, but that's one to watch as well. And in Connecticut, we just had a recent success there as well. Exxon had removed that case to federal court, and the federal district court just sent that back down to the state court, where the case will proceed to, again, litigate motion to dismiss. That's sort of the standard operating protocol of the industry, where they try to remove these cases to federal court. When that fails, they try to get them dismissed. When that fails, then they face, the writing's on the wall, and they have to face discovery and trial. So that is where we're at. I think, it's been quite a journey to get to this point. A number of these cases, as I've mentioned, have been held up by procedural delay tactics by the industry. And it's not to say that it's smooth sailing from here, but I think these cases are really well positioned to proceed in state court and for us to get resolution in the coming years. And I think that this is almost the beginning of this wave. I think we're very likely to see many more municipalities, cities and counties and states join this charge and this mission to hold the fossil fuel industry accountable for the lies and the deception and the damages that they've caused as a result. Yeah. So I think I'll leave it there.
Yeah, I might just add to that, just in terms of a little bit of a PSA for those of you who are interested in following these things going forward. Alyssa did a great job of highlighting some of the most important cases. I think it's important to stress that we're talking about state court litigation. So what that means is that it's not like Maine can just join the case that Rhode Island filed. Maine and Maine communities have to file their own cases in Maine court and proceed that way if that was to happen. And the same thing holds true for Georgia, Florida, North Carolina, whatever state you want to highlight. But sitting in New England as we are, I think watching the Massachusetts case and the Rhode Island case is particularly important for us, just given the status of those two cases. And then the Baltimore versus BP case, which is the one that the Supreme Court did actually take up and issue a ruling on, is one of the cases that's furthest along in getting the most national media attention. And Alyssa kept saying, they're trying to remove to federal court because they feel like they will be more successful there, which I can tell you is 100% certain that they will be more successful there, because there's Supreme Court precedent that makes it very difficult, if not impossible, to bring these claims in a federal court. And I won't get into the details of that, but suffice it to say that like federal cases that were brought by multiple states and multiple actors across different states together was the first way that lawyers tried to hold these companies accountable in courts. And the Supreme Court, almost a decade ago now, basically shot that down. And so now we're left to do this state by state approach. And so it's not as if there's a sort of national or a federal, all the states joined together version of this. And so it's really important to pay attention to these cases. And indeed, I think those cases that Alyssa mentioned are the ones that are kind of the most important for us sitting here in Maine to be thinking about. Kathleen, did you have something you wanted to jump in? You look like you had something.
I do. I'm really excited, and we've got a bunch of good questions, and I can't wait to get into them. But before we do, well, do you have more? Or is this a?
I think this is a good place.
Q&A?
Yeah, I
Okay.
think we're ready to go to Q&A.
Great. So the first thing I want to do is build on what Anthony just said about the difference between sort of joint action at a regional level and the potential of state and municipal action. We all know here in Maine that communities are on the front lines of the climate crisis, and they're also on the front lines of the efforts to protect us, to protect our families and homes and livelihoods, and hold the polluters accountable. So I'm super excited to share with all of you a little information about Leaders for Climate Accountability. It's a national network of elected officials who support holding corporate polluters accountable for their role in creating and perpetuating the climate crisis. So later this afternoon, we'll share a link to help you learn a little bit more about Leaders for Climate Accountability. And if you have someone in mind, somebody on your select board or city council, someone who represents you in the state house, someone you think might share this mission, there's a space to actually nominate that representative and loop them into Leaders for Climate Accountability. So you all play a very important role in helping to get this strategy out there to the folks who really have the power to make some pretty big decisions here. All right, let's go right into questions. Anthony, really appreciate the sort of like, this is why we can't just join on, right? We can't say, oh, well, let's team up with our New England neighbors and join that Massachusetts state suit. Is this what makes, is this why the cases that you guys were talking about this morning, they're different than some of the cases that we've heard about? I know like Conservation Law Foundation sued Exxon 5 years ago for federal environmental, for violating federal environmental laws or failing to incorporate foreseeable climate risks in applying for some permits at a Boston terminal. And that case has gone to the First Circuit. It's still working its way through. Seems like long odds, long timeline. Is this a slam dunk, or is what you're talking about totally different?
I could take that one, or at least start at it. So it's important to distinguish these cases from the type of environmental case that you're describing, right? That is a challenge to a permit is a pretty classic type of environmental law case. And that's suggesting that, Exxon in that particular instance, right, didn't do enough to think about the climate impacts of a facility like the one in Boston. And in fact, what the hope is there is that had they considered those climate impacts, they wouldn't have put that facility there, right? The idea is, in other words, those cases are really focused pretty intensely and acutely on mitigation or the lack of mitigation. Like, let's cut down on fossil fuel use. Let's stop permitting fossil fuel facilities. What these cases that we've been discussing today are about the fact that climate impacts are happening now. They will happen regardless of how much we cut emissions in the next decade or so. And those impacts are very costly to communities, right? Communities in Maine and communities elsewhere. And someone has to pay those costs. And the contention of these lawsuits is that these companies that knew about climate change, they knew it was happening, they knew their products were causing it, and they did nothing. And in fact, they hid that knowledge from the consumer. Maybe they should pay some of that bill, right? Maybe they should pay a little bit of the cost of making our communities able to survive from the environmental catastrophe that they helped bring on, right? Alyssa, did you have anything you wanted to add on that?
No, I mean, I think you made a good point. I mean, these cases are not about solving climate change. I mean,
Right.
that's really not what it's about. It's about shifting the burden of the cost from the taxpayers. And I mean, it's going to have to happen one way or another. And whether it's local or state government that has to pay the cost, or the polluters and those responsible for creating the problem, well, that's where we see that, you know, it lies with them, and they should be held liable for that.
That's super helpful. And I think it's really tempting to say like any suit against Exxon is comparable to any other suit against Exxon, but this really helps to see like you're talking about a completely different legal strategy, one that actually maybe is more comparable to the tobacco lawsuits. Does that make sense?
Yeah, absolutely. I mean, I think in many ways, you know, the lawsuits that we're seeing being brought, you know, from California to Hawaii, Minnesota, Charleston, South Carolina, all across the country. I mean, they are being closely modeled after, you know, the lawsuits brought against tobacco, lead paint manufacturers, you know, opioid companies. I mean, they very much follow a similar like theory and case theory and narrative about the fact that they had, you know, a body of knowledge, and they had information about the harms associated with their products, and they lied and deceived consumers, policymakers, the media, and more. And for that reason, they need to be held accountable for the harms. So it's very much, you know, a strong parallel to those cases. And oftentimes the complaints themselves are modeled after the lessons learned from those streams of litigation.
And though they've been maybe in a different sort of different subject matter, we've seen some pretty significant settlements as through those streams of legislation. So maybe that's pretty encouraging for what we might see in the climate accountability. Is that safe to say?
Yeah, it's hard to make predictions about what might happen, but you know,
you guys are lawyers. I'm not going to trick you into this. I see what you're doing here. You're not going to guarantee anything.
This is why it's important to watch all of these cases in other states, because one favorable judgment in one state court case could start the dominoes falling of settlements across the country because of concern that will repeat itself, right? And so it is certainly, it's possible to have a situation like tobacco where you have multi-million, billion-dollar settlements. I would say it's very hard at this point to predict one way or the other whether that's a realistic possibility. We're very early stages here.
So with that sort of disclaimer, do you have a hunch about whether a statewide suit or a municipal suit would be more effective? And thinking, as I'm sure many of us are, of like, okay, we're in Maine. We weren't on that map at all yet, but which should we be? Which should we want it? Which color green do you want us to be?
Alyssa, you want to take that one?
Yeah, I don't know that it's necessarily one is more effective than the other. I think it really comes down to what makes sense for the community and the state, and you know, looking at the legal landscape, the political landscape, and you know what the particular impacts are in a particular area. I mean, you need to know that there's severe harm that can be attributed to a particular defendant, and it really does depend on, it's going to be fact specific for every jurisdiction. So it's not going to be a one size fits all approach. And that's why we have to look at every situation independently from the other.
Wow, I'm so impressed by all of the sort of moving pieces that you all are helping us put together. So thank you. Another question, what's the intersection, if any, between carbon pricing and liability? Is that another for liability for environmental harm? Is that another possible vein here?
Sure. So I can talk about that. So um, let's start with just a very basic concept, or like sort of the originating concept of both of these things, of what we call in economics an externality. Right. So an externality is a cost that a business, in this case, these large fossil fuel companies, are imposing on society, and they aren't paying for it. Right. It's not part of their bottom line. When you factor their profit, their costs, and their profit, their income, their revenue minus their cost gives you their profit. Well, that cost doesn't include that social cost of harm that they're causing to the environment. And what the price of carbon attempts to do is to put a price on the carbon emissions so that we can include it in a calculation like that, so that they have to pay a cost for what they're doing. What these lawsuits are doing is saying, hey, you never paid for all the carbon that you already put in the atmosphere, and now we're all paying the cost. So shouldn't you pay some of those costs too, right? It's kind of retroactively pricing the carbon that they've already put into the atmosphere, if that makes sense. So I view them as very related, but if we put a forward-looking carbon price on, from here to eternity, it's still not going to solve the problem of all the carbon that they already put in the atmosphere and paid no costs for. Does that make sense?
That's really helpful. So it's almost like, yes, we could start carbon pricing from here out, and quite likely should, but we still need a mechanism to recoup all of the many years that they weren't paying that carbon price.
Right.
Got it. Okay. It feels like, Alyssa, with those documents that you showed, with the way you've explained this, this feels so obviously true, right? It's accurate. What possible defense are the fossil fuel companies meeting these claims with? How can they deny what you just showed us in black and white, highlighted?
Well, they've made a number of defenses. In part, one of their first responses was when AG Healy and Schneiderman, former AG of New York, launched an investigation into what they knew, and Exxon responded with the fact that this is an abusive process and that this is a conspiracy, and they're targeting Exxon, and it's all part of some grand conspiracy by the progressive blue, states to bring down the company and the industry at large. So that was one tactic that they employed. So far, they've tried this in a number of states, initially in Texas, and then it went to Massachusetts and New York courts. It's been shut down universally. The arguments that they're raising now and trying to get these cases dismissed are, one of their favorite arguments is that they were operating at as federal officers at the direction of the federal government in, undertaking, the work that they did in their fossil fuel operations, and that this implicates a federal interest because of the connection to the federal government, and that these claims are somehow, they kind of flip the argument on its head. And even though the cases are focused on them as producers and the nature of the products that they put into the stream of commerce, they claim that these cases are all about emissions, and therefore that the claims are preempted by the Clean Air Act. So they kind of turn it on its head and reframe and recharacterize the arguments that are being put forward by the plaintiffs to their advantage, and trying to say that these should be in federal court and they should be preempted by federal legislation, specifically the Clean Air Act. They also like to claim that this is not an issue to be addressed by the courts, that this is an issue that is best addressed by the political branches, by the legislature and executive branches. It's another one of the arguments that they've put forward. But on the flip side, here they are saying that in the courts, but they're actively lobbying against legislation in Congress. So you can't have it both ways. That's two of the primary arguments that they're putting forward.
It must be just absolutely infuriating to get deep enough into those arguments that you can explain them to us. So thank you, because I'm getting riled up just listening to your summary there. One thing we've talked a little bit about in various subject areas over the course of these lunch and learns is we're really good as an environmental community, as Maine conservation voters and all of our friends at influencing the legislative branch. What's our role as citizens, as members of the public in these court battles? Because I'm completely sold on this strategy, but what do we do about it?
I mean, well, I can speak in general terms, and I bet Alyssa has some very specific recommendations for you. But I would say that you touched on it earlier when you asked the question about settlement. So for these companies, the calculation of whether to settle these cases is a complicated one. And right now, clearly, they think it weighs in favor of continuing to fight them and not to settle with these communities. But if the public pressure, right, there's the pressure that's happening in the courtroom and what's happening in the court and the developments in a particular case, but there's also the PR that's associated with all of this. And to my mind, there's a positive PR story to tell if you are one of these corporations and you fund the necessary adaptation to keep communities thriving rather than be inundated by rising seas, right, for instance. And if that positive PR outweighs the negative PR that comes from you just refusing to accept responsibility, then all of a sudden you're willing to pay a few $1 million just to get out from under these pieces of litigation. And so I see this as, the role of the public here as, really helping to highlight in the popular attention and keep a spotlight on these companies and make them really feel the heat, pun not intended, for not just settling these cases and helping these communities to stay thriving. Because that's all we're really asking them to do in these pieces of litigation is to say, hey, these communities are hurting as a result of climate change. Can you help them out? And if it becomes very painful for them to continue resisting, maybe it will just be easier and make more sense for them to settle. So that's like part of the settlement calculation. And I would bet Alyssa has some pretty good suggestions on that front and how to put some of that pressure.
Well, I think that was a great response. I think public pressure and your voice matters, and your city and county council members want to hear from you. Mayors want to hear from you. State legislators want to hear from you. I think to the same vein, I think, having an influence on whether or not a case were to settle or not, sort of the pathway for a particular case, like whether a case gets filed or not. I think, lending your voice and making a statement, or working with city council members to pass a resolution calling on, either, your municipality or the state, whatever is most appropriate, to take legal action. That's been really effective in New Jersey, for example. There are a number of municipalities that have passed resolutions, really making a commitment and calling on their elected officials to take legal action. So I think there are a number of ways that you can engage with your local elected officials to start that conversation. And if that's something you're interested in, we're happy to talk to you about that.
That's super helpful. And just to go back to that call to action, it seems like figuring out who in your community should be nominated for that Leaders for Climate Accountability, and then not just nominating them, but connecting with them and saying, this is what I think we need to do. So
Kathleen,
there
can I
were,
add one more thing
yeah,
to that? I mean, and just another way to like, for you know, interested parties, for all of you, for MCV to participate in the process. I mean, if and when there's a lawsuit filed, you can participate as a friend of the court, and you know, amicus status, to participate and share your views and your perspectives on this case as part of the legal process. So that's another opportunity as well.
that's great. And just so everybody knows, MCV will definitely is stepping up to help sort of compile those resources, what it looks like in Maine, and we will definitely keep you posted. So that folks know, though, what does it entail to bring a suit like this for a city or a town or even at the state level? Is it, what should we know when we make that pitch to our local electeds?
Well, maybe I'll kick this off, and Anthony, I'm sure you have some thoughts as well. You know, I think one of the things that we hear from folks, you know, the number one issue and concern that they have is resources, and whether they, you know, have the person power or the financial resources to bring a case like this. I mean, going up against the fossil fuel industry, I know South Portland has had quite an adventure in taking on big corporations recently. And, you know, I think you have to undertake a bit of a risk assessment of, you know, what makes sense for, you know, for you and your constituents. But, you know, I will say that in almost each and every one of these cases, they involve outside counsel. So, you know, while the city or county or state AG is, you know, taking lead and representing, you know, the plaintiffs in these cases, almost in every case, there's outside counsel that's hired on a contingency fee basis. So that doesn't require any output or any, you know, line item budget in anyone's, you know, line item in anyone's budget that would have to be allocated for financing this type of lawsuit, which is, you know, pretty standard for these types of, you know, large complex litigation efforts that are being undertaken. So I would just, you know, advise you that when resources, you know, which is oftentimes the first thing that comes up in our conversations, when that comes up, I mean, you can just assuage people that can be addressed and that can be dealt with in a number of different ways. And I think the legal fees and costs are not going to be what people think they are.
That's really reassuring, and thank you, because having that support is absolutely essential, because it does feel kind of overwhelming to think about how, you know, I can just imagine my select board members, if I were to go to them, would say, whoa, you want me to do what? But to say, no, we want you to do this with a lot of support. And then talking about the resources on the other side, what kinds of remedies could these types of cases help fund? And is there anything that they couldn't cover?
Well, so the remedies have to be attached to the harm that happened, right? So, or that is ongoing in this case. So, you know, it depends on the community that's the plaintiff in the lawsuit, right? Imagine a lobstering community or the Lobster Fishermen's Association here in Maine as an example. Their damages are going to be result of decreased catch, right? Expected decreased catch. You can imagine a fund to help compensate those lobstermen for realizing a decreased catch as a result of the activities of these corporations. That's not an unprecedented type of fund, right? If those of you who remember the BP oil disaster, when Deepwater Horizon exploded in the Gulf of Mexico, right, there was a fund set up to compensate a lot of different businesses and small businesses and people who made their livelihoods off of Gulf of Maine marine resources or Gulf of Mexico marine resources. And that fund was drawn on by those individuals making claims against it. You could see a similar thing happening here, right? Even more sort of even more elementary or basic are things like better flood prevention technology in our coastal cities, right? So that's just what we'd be asking for there is really just funds to pay for things like seawalls and the like to make our coastal communities more resilient to the severe storms that we're seeing and the rising sea levels, right? And that's something that, if you live in a coastal community in Maine, you for sure have experienced, at least to some extent, how that's impacted our lives here in the past even 5 to 10 years. Is there anything else you can think of, Alyssa?
Well, I was just thinking in terms of, the cases that are being brought for fraud and deception, it's not damages necessarily, but it's penalties. So every time they put a particular ad out into a certain, media market, they could be hit with a penalty for every single time that ad has run. Or, they could be, a court could order them, to essentially stop running these advertisements and to run a corrective advertising campaign that actually tells the truth about their products. So there are other ways. So I think, damages and penalties, there certainly would be a compensatory element to this. And I think that that's what, a lot of communities are interested in. But I think when it comes to the fraud and deception, there's, a remedy that, you need to stop what you're doing. You need to stop the lies and stop the deception.
One of the things that sort of became really clear through the Maine Climate Council process that we wrapped up last December and in the new state climate action plan was that the communities that are really on the front lines here often do not have the resources that they need or the capacity to do some of the really essential adaptation and resilience planning, right? To even figure out what they need. And there's actually $20 million in this year's budget for state adaptation infrastructure, a new fund. Do you see is it possible that cases like this could help fill that fund and support that planning at the local level? Or do you have to sort of know going into the case, we want to do X, and this is how much it would cost?
At least in the complaints that have been filed thus far, there's no number. At the early stages of litigation, there's no number attached. I mean, that would come in later during a fact-finding process. But absolutely, I think in response to your question about whether or not these, the funds that might be awarded as a result of litigation, whether that could be directed to a fund like that. I think that's absolutely within, the authority and the discretion of, the legislature to do that.
Well, I have to say, from all of the messages that have come through in the chat, there is a lot of interest in this, and we're so grateful to both of you, Alyssa and Anthony, for sharing this update and really getting our brains thinking, our wheels turning about what it might look like here in Maine. So that everybody knows, we'll send out a follow-up email later this afternoon with some information about that Leaders for Climate Accountability network. And also, because it's so clear that there's interest in this, we will also start pulling together some MCV advice about what towns might want to do. If you think your city councilor might be a good candidate for a longer conversation, either with MCV or with Alyssa or with Anthony, just let us know. We can make that happen. I hope you will join us next week for a very different program. Next week's Lunch and Learn is about seabird conservation in Maine. And we'll be joined by Dr. Don Lyons, who is the Director of Conservation Science for Audubon's Seabird Institute. I've seen some pictures. He had shared a picture of him snuggling a little puffin chick, which has a special name that I can't remember, but you'll have to tune in next week and he'll tell us all about the puffins and the terns and the mures and all of those just absolutely fabulous little creatures. I hope we'll see you then. Until then, have a wonderful, wonderful weekend. Alyssa and Anthony, thanks a million.
Thank you.
Thank you.